were the predicates for those felony murder counts that were vacated by operation of law, but did not automatically say that the trial court erred in not sentencing on those. In Noel, the Supreme Court ordered the trial court to make a determination, and I quote, whether the remaining non-murder felonies merge as a matter of fact into the felony murder conviction, and that's why the case was remanded back. And interestingly, in the Noel case, the Hewlett case is cited, 296 Georgia 49. That's a 2014 Georgia Supreme Court case. Same issue as before about the felony murders being vacated by operation of law. And then but in Hewlett, it was a malice murder case as well. But it gave some instruction, and I suppose that's why the Noel court relied on Hewlett, gave some instruction about whether there would in fact be merger. And in Hewlett, the important distinction was whether the felony that then led to felony murder was followed almost immediately by the death of another. So the question was whether there was a, quote, deliberate interval between the offense and the death. For those reasons, Your Honor, I ask the court to find as a matter of fact that those felonies do merge and that there is no reason and no statutory obligation for the court to sentence on the other remaining felonies that the state wishes to proceed on.
So I understand what you're saying. What you're saying is there's no deliberate interval then, because there are other cases.
Yes, I'm sorry, I just realized that I put that. Yes, that's exactly what I'm saying, Your Honor, that all of this took place in a continuing manner, that there was no stop and start between the beginning of the chase, we'll call it, and the end, which led to the tragic death. So for that reason, I think that it can be distinguished from some of the other cases that Ms. Dunikoski may be relying on. But it certainly stands for the proposition that simply because the felony murders are vacated by operation of law does not mean that the underlying felonies have to be sentenced upon. They don't still exist. They aren't still there. There still is a question of merger by operation of fact.
Okay, understood.
All right. So, between the two statutory sentencing options that are before this court, the state is asking for the sentence of life without the possibility of parole. And grab this. They made that position known back in September of 2020, specifically September 16th of 2020, when they filed a notice of the state's intention to introduce evidence in aggravation of punishment. And in that notice, Your Honor, under the final box that's checked, the state indicated that it intended to seek life without the possibility of parole by relying upon three statutory code sections: 1651, which is simply the murder statute; 1710-2, which is the statute of criminal procedure that provides for what we're doing here today, the presentation of evidence in support of any sentence that each party is seeking. And finally, 1710-6.1 is the third code section on which the state relied in seeking life without the possibility of parole. And in that code section, that is, as the court knows, sets forth the inability for any individual who is incarcerated for the first time on an aggravating, on a violent felony, which results in a sentence of life with the possibility of parole, to not be considered or any form of release or parole until after the service of 30 years in prison. Those were the reasons, the state said, we seek punishment of the defendant in this manner. And at the top of their notice of seeking aggravation of punishment, the state indicated in September of 2020 that they intend to introduce evidence of any convictions, juvenile adjudications, and other crimes of the defendant furnished as part of the reciprocal discovery. What the court knows is that there are no other crimes and no other pieces of evidence that support that statutory ground for seeking aggravation of punishment. So in the absence of that sort of evidence, which is the evidence the state indicated back in September it would provide, an absence, as the court knows from the bond hearing and having had those documents provided to it, there is an absence of any criminal history by Greg McMichael, which is a significant factor in your consideration of what sentence to impose. So, without any of the aggravating evidence that was set forth in the notice, the state has told this court now, we wish to simply rely on the facts of the case. And in particular, what Ms. Dunikoski argued is, number one, what she called a pattern of vigilantism. But every example she gave, Your Honor, was not, in fact, vigilantism, gathering up folks who have no authority to do so and taking the law in your own hands. Her examples were notifications that Greg McMichael made to law enforcement about suspicious activity and suspicious people in their neighborhood. And in fact, that is exactly what a neighborhood watch program is all about. That's what Officer Rash testified to you we can't survive without neighbors who will let us know what's going on and provide us the evidence we need to investigate crime. Very different and not at all related to some sort of pattern of vigilantism, which is a violent act. The second fact on which the state said that they were relying, based on the facts of the case, to seek an aggravation of punishment from a life with parole, meaning no consideration for anything less than 30 years, all the way up to life with absolutely no window of opportunity, is that Greg McMichael has shown no remorse or empathy. The difficulty of our adversarial system, a system that is the best system we know of, is that it still leaves no opportunity for an accused to turn and be the person you know he's been for 66 years, and offer condolences to another person for their sadness and for their loss. The other problem with the adversarial system that I know all too well is that an individual who is committed to telling the stories, to explaining to a jury how an individual got where they are right now, often feels like a defense attack on the surviving relatives of this loved one. A vigorous defense often results in the sadness of people who have lost a loved one. But those are the roles that we honorably take on. Our remaining stoic in the face of heartbreaking testimony this morning from people who have lost a loved one is because that's our role in this courtroom. This court has very handily taken care of emotional outbursts to make sure that we're dealing with law and facts and not the kind of thing that can otherwise affect a court or a system that should remain free of those sorts of emotions. So, Your Honor, like Mr. Rubin said, it really isn't anything that I suspect the court will be taking into consideration, the fact that Greg McMichael didn't and couldn't stand up and offer his genuine sadness and condolence for the loss of a loved one, because he's facing other crimes. He's facing charges and trials on other crimes, criminally and civilly. And I hope the court knows that what we need to do to tell his story in any case involving justification, of which there was sufficient evidence to move forward with a request to charge, is that there has to be a clear, palpable, full-throated explanation to a jury about how it is that an individual put himself in a place where our clients felt they had to defend themselves. It must be terribly difficult to hear when it concerns your loved one who's no longer here. And it probably feels cold. But the court knows those are our rules, and it's the only way to make sure that our system operates as it should. So, Your Honor, with no statutory aggravating circumstances, like in a death penalty case, how do you decide? We now know there are no statutory aggravators based on the notice. We now have told you about how the factors that the state said arise out of the trial actually escalate this out of life with parole to life without parole. I suggest to the court that we rely on a wonderful system that the federal United States Sentencing Guidelines set up and the United States Code, and that's you look at two things. You look at the nature and circumstances of the offense, and you look at the history and the characteristics of the defendant. Let's talk, number one, about the nature and circumstance of the offense. The best indicator of what happened in order to respect the jury's verdict is to listen to the jury's verdict. The jury found that Greg McMichael, as a party to the crime, committed felonies that unintentionally led to Ahmaud Arbery's death. After deliberating for over 10 hours, over 2 days, they came back with a unanimous verdict that says, in effect, Greg McMichael did not leave his home that day hoping to kill. He did not view his son firing that shotgun with anything other than fear and sadness. What this jury found is that this was an unintentional act, one that Greg McMichael did not plan, devise, attempt, or seek to have the result that happened. So if life without parole is a sentence that is held for only the worst of the worst, it simply can't be a sentence for a person who never intended that tragic result that took place on February 23rd. If you never wanted another person to die as a result of activities you took part in, you can't be the worst of the worst. Secondly, Your Honor, under 1710-2, the things that this court should consider, you should take in account extenuating or mitigating evidence that you heard in trial. You heard in trial, based on the presentation of evidence over several days, that Greg McMichael sought to detain Ahmaud Arbery for one reason and one reason only. It was not for sport. It was not for evil. It was for the same reason that the police who repeatedly came to Satilla's shores came there for. It was to get to the bottom of Ahmaud Arbery's nighttime intrusion into Larry English's house. The verdict spoken by this jury, based on their understanding of the law of citizen's arrest, found that Greg McMichael did not possess the information he needed to possess to attempt to execute a citizen's arrest, and that meant that Travis was not in a position to defend himself because he was the initial aggressor, if there was no citizen's arrest that could be supported by the facts and the law. That is the offense that you heard. A reason that is not an evil reason, not a reason of hate, not a reason of anything other than trying to help other people to get to the bottom of this inquiry. Further support of extenuating and mitigating circumstances from the trial you saw in the video itself. As painful as it was to watch, I'm sure the court does recall that when you saw Greg McMichael in the back of the pickup truck, in the bed of the pickup truck, not directing, not doing anything that's going to be the person who's advancing the progression of this from the chase, the attempt to stop and detain Ahmaud Arbery, into what it ultimately became, you most importantly saw that Greg McMichael never even sought to remove his handgun from its holster until after you heard the first shot that took place in front of that pickup truck. So while he's on the phone begging for 911 to come and help, that is the moment he removed his handgun and never fired a shot. That is the nature and the circumstances of the offense that this court heard and upon which the jury reached their verdict. So now, the history and the characteristics of Greg McMichael. Because we know that history is the only reliable measure of a person's character. Greg McMichael is 66 years old. So, Ms. Dunikoski, there has not been just 99 good deeds, but more like thousands and thousands of big and little good acts of kindness, charity, goodwill throughout this man's life. Greg McMichael is a good man. He's not a perfect person. None of us are. But he's lived a good life, a life dedicated to service. And that does count for something. The choices he made as a young man, all the way through the rest of his life, to serve, not to acquire wealth, not to do anything that brought extreme attention to himself, but to quietly go through the business of choosing career options to help other people. You heard at the bond hearing and during the trial of this case, Greg McMichael chose as a young man to serve this country by enlisting in the Navy. And after an honorable discharge, some years later decided to serve his community. Over 30 years in law enforcement. He was not a patrol officer, then later a detective, then later an investigator with the DA's office because he sought power. There was no evidence of anything like that. There were never any complaints about him being aggressive, about him seeking to take matters in his own hands without seeking the appropriate backups. He was not a gun-toting, aggressive officer. His wife testified during the bond hearing. One matter of pride that Greg McMichael always had is that he never had to discharge his weapon during the service of his community. And of course, he wasn't a law enforcement officer or an investigator for the DA's office for money. That's laughable. He did it to help, he did it to serve and protect other people. His post file that the court had into evidence during the bond hearing indicated numbers of commendations and notes from people in the community indicating how grateful they were for his willingness to participate in a case, for his willingness to go the extra mile, for his kindness to families of people who had lost loved ones. Things that are above and beyond the work that he needed to do. Those examples of commitment, of empathy and kindness are further examples of who Greg McMichael is. He is a husband for over 38 years through thick and thin to the woman that he met and married months later. He's a son, a brother, a father, and a devoted grandfather. So yes, that's how I stand before you, Your Honor, representing Greg McMichael, who has now been convicted of murder, and I say without hesitation, he remains a man of goodness. For 66 years, I calculated that's 24,105 days of life on this planet. And we're here, not for a small matter, not as if all of the other erases what happened on that day, but we are here for a driveway decision to pursue Ahmaud Arbery and a 5-minute chase that ended in tragedy. He needs to be punished. But how that contrast between a life of goodwill and service and the bad decisions that were made that day that resulted in a tragedy that the jury said unanimously he never intended could end up in the state seeking the sort of sentence that is devised for the worst of the worst is not consistent. In many courtrooms, Your Honor, that I appear in, right behind the judge, and it might be that way in Chatham County, there is the seal of the state of Georgia. And our Georgia state seal has 3 words on it: wisdom, justice, but most importantly, moderation. Life without parole versus life with the possibility of parole may be nothing more than academic for a 66-year-old man with significant health problems, because it means 30 years, at the very least, in prison. But it is an important distinction. It will affect all sorts of other things that could happen to Greg McMichael while he's in prison. But most significantly, it is the only way, Your Honor, to honor the jury's verdict that Greg McMichael committed crimes for which he never intended the result. For that reason, for the lack of evidence of aggravation, for the presence of significant evidence of extenuation and mitigation, we ask the court to sentence Mr. McMichael to life with the possibility of parole.
Mr. Goff.
Your Honor, we're going to need a short recess before we proceed. I need to triple check a matter.
Okay.
A 5-minute recess should be sufficient.
All right, well, let's make it realistic. Let's take a 10-minute recess, and then we'll come back on the record at 1:45. Thank you.
We've been watching the sentencing hearing of the 3 men convicted of killing Ahmaud Arbery. We're going to take a quick break. Stay with us.
I'm Norah O'Donnell in our nation's capital. We're here at the White House with the President of the United States.
Thanks for having me. I appreciate it.
The Supreme Court building behind me is once again at the center of a monumental battle. Tonight, a congressional investigation sparked by reporting from CBS News. Our exclusive access to the presidential platform. We will witness yet another moment in history.
The CBS Evening News with Norah O'Donnell from Washington, D.C. An original documentary on CBSN.
50 shows running, the lights blinking.
People fight their entire career to get to Broadway.
You've trained your entire life.
Spotlights, drama, passion.
This is what we live for.
Until COVID turned off the lights.
It's like going from a bright light to pitch black.
Scenes from Broadway's unique struggle with COVID.
It was devastating.
Broadway contributes about $15 billion to New York City's economy and 100,000 jobs.
The sound team, the lighting team, everyone.
The world does not realize how big this is.
This is how we make money.
This is a specialized industry. You don't tell a doctor to go get a serving job. Why are we different?
Are we going to be able to pay our rent? Am I going to have food?
What will happen in Broadway's new opening act?
We're in uncharted waters again.
The show must go on.
There is reason to hope again.
I think people are going to be crying. I know I will.
An originals documentary on CBSN. Stream now.
Welcome to CBS Mornings.
Up next, stories you'll be talking about today.
That's a big deal.
People stop me on the street and say, I always learn something new every day when I watch your show.
This morning, we're going to begin with some good news.
Oh, you just put me in a good mood.
Just follow me. I'll lead the way.
There's always something new under the sun. CBS Mornings, weekdays on CBS.
Hi, everyone. I'm Nikki Batiste. Welcome back to CBSN. Here's a look at our top headlines this half hour. The Supreme Court is weighing 2 Biden administration rules for workplace vaccinations. Their decision could impact up to 80 million people. This comes as global COVID cases surge past 300 million people. Academy Award-winning actor Sidney Poitier has died. The Bahamas native was the first black man to earn a Best Actor Oscar. He also received the Presidential Medal of Honor in 2009. Sidney Poitier was 94. And the president looks at the bright side of the latest jobs report, focusing on the pandemic low unemployment rate. But the U.S. economy produced less than half the jobs financial experts had predicted. Tax season is around the corner, but if you received the child tax credit and were counting on a big refund, you may be out of luck. The child tax credit was expanded under President Biden's American Rescue Plan, but despite the bigger credit, some parents will take a hit. The biggest issue? How the tax credit was paid out. To explain more, I'd like to bring in CBS News Money Watch reporter Amy Peakey. Amy, can you explain to us why the way the child tax credit was allocated will impact parents' tax returns?
Yeah, absolutely, Nikki. So what's really interesting and important to understand is that before 2021, before the child tax credit was expanded, parents could claim a tax credit of up to $2,000 per child. Now, the American Rescue Plan bumped that up to $3,600 for kids who are younger than 6. And for kids between 6 to 17, parents get $3,000. Now, people who got these the child tax credit will realize that half of that amount was paid out in monthly checks between July 2021 through December. The last check landed December 15th. And there are 39 million households who got these checks. The IRS estimates that something like almost 9 out of every 10 kids in the U.S. got one of these checks. Why that's important is because the way it's structured is the other half of that tax credit will be claimed on your 2021 tax return, which will soon, people start filing those pretty soon. But remember what I said about the original tax credit being $2,000. Well, half of the bigger amounts is actually less than that. It's $1,800 for younger kids or $1,500 for kids between 6 to 17. So take a family with 2 kids who are 8 and 10. They're going to be able to claim $3,000 in tax credits through this expanded tax credit on their tax return. But before 2021, they actually claimed $4,000. So that's a loss of $1,000 in tax credits. And I also just want to point out that tax credits are dollar for dollar reductions in the amount you owe the IRS. They are extremely valuable. And the CTC, even more so because it's fully refundable, meaning you will get that money in your refund. So the result is your refund could be lower because you're just going to have a smaller tax credit potentially.
Amy, what are the key points recipients of the tax credit need to know when they file this year?
Yeah, absolutely. I mean, number one, it's really important to keep your eye out for a letter that the IRS is going to send you this month. It's coming in January. And that letter is going to tell you how much you received in the advance payments in the second half of 2021. The reason why you need that, or the reason why you have to hold on to that, is because it's going to help you calculate how much to claim on your tax refund. And this is important because we saw this last year with the stimulus checks. People guess. They're like, I think I got this amount. They put down the wrong amount. It doesn't match what the IRS has on file. And when that happens, your return, your tax return, is flagged by the IRS for a manual review. It means a human at the IRS has to look at your return. And some people might recall that there were tens of millions of tax returns that fell into that situation last year with some kind of error. They were flagged, and then you could end up with weeks or months of delays in getting your tax refund. So number one, keep that letter. Don't guess. Look at it and make sure you're putting the right amount down on your tax return. And then, secondly is tax experts are recommending that you file as soon as possible because you will get that extra money from the child tax credit quicker if you do it that way. So, a lot of people are still struggling. They need a little extra money. So, if you're in that situation, definitely file sooner, get your tax refund as soon as possible, and get that extra tax credit money earlier.
I know parents welcome that extra money, and not every parent will see a smaller refund this year. Who will see more money and who will see less?
Yeah, absolutely. I mean, there are a lot of families who are in line to get a bigger tax refund. One group of these people are parents who had a child in 2021 because the IRS based its calculations and its estimates on who should get this tax credit on 2020 returns. So that means if a child was born in 2021, they don't know that child exists, and you probably didn't get those monthly checks. So those parents in that situation will probably get a bigger tax refund than they did in previous years because they can claim the whole tax credit on their return. The other thing that's important is a new or expanded tax credit, the Child Independent Care Tax Credit, which was also expanded through the American Rescue Plan. That was bumped up from $3,000 per child up to $8,000 per child. This is for working parents who paid for daycare so they could work or look for work. And there are some restrictions on this. As for children who are under 13, for example, you can actually pay for a relative to watch your child and claim this tax credit, but not a dependent. So, for instance, you can't pay an older sibling to watch your younger child. That doesn't work, doesn't fly with the IRS. But, those people could see definitely more money in their tax refund this year.
Amy Pichi, thank you for your insight and time.
Thank you so much.
Violent unrest has escalated in Kazakhstan, where the country's president issued a shoot-to-kill order against anti-government protesters. Demonstrations began on Sunday after gas prices doubled. Officials say 26 protesters and 18 officers have died in the wave of violence. Before the shoot-to-kill order, Kazakhstan's president had said constitutional order was mostly restored in all regions. But this morning on CBSN AM, CBS News reporter Mary Ilashina said it's hard to tell what's really going on in Kazakhstan.
It's not entirely clear what he means by constitutional order. Like, the law enforcement did take back a lot of significant government sites like airports and government buildings in a lot of cities. But there's still this so-called security operation in the biggest city, Almaty, where we know that law enforcement is tracking down people who protested. The officials are calling them terrorists and bandits. But we know that people are being shot on the streets of Almaty today, and that the clashes are ongoing. And it looks like the last night was pretty bloody in that city. And in the morning, authorities reported that at least several dozens of people were dead, including some security officials. At least 18 security officials have been killed, and around nearly 4,000 people have been detained. So things are not back to normal yet, and they're not calm. So we're still yet to see how the authorities are going to behave today, and whether this night is going to be as unfortunately deadly as the two previous nights before. And we also know that in some other cities across the country, back in the region where the protests over fuel started, there's still some protests going on. People are coming out in several hundreds, in some cities, a couple of thousand people are coming out to main squares peacefully and demanding a change in power and a number of other political demands. So control, I think, is still up in the air.
If you want to watch Mary's report in its entirety, just head to cbsnews.com. There you can download the free news app. Legendary actor, activist, and director Sidney Poitier has died. Poitier was the first Black performer to win an Academy Award for Best Actor. He was 94. The actor was revered for his work on and off screen. Poitier utilized his platform to champion the civil rights movement. His roles on screen challenged the racial norms of the time. The son of a Bahamian tomato farmer, Poitier moved to New York City at 16 to pursue a career in acting. 7 years later, he appeared in his first film, No Way Out. His role in the 1963 movie Lilies of the Field would earn him his first Oscar for Best Actor. Entertainment Tonight co-host Kevin Frazier joins us now to talk more about Poitier's life and legacy. Sidney Poitier's career spanned over 5 decades. Tell us a bit about his legacy and what his passing means for the entertainment industry as a whole.
You know, Nikki, when you talk about Sidney Poitier, you talk about an African-American man of elegance, grace, and someone who challenged the racial stereotypes of the time. Don't forget, he came to the United States and was part of the American Negro Theater Company, and from there worked his way up. He traded his acting lessons for his janitorial services when he first got there. But when you talk about him, he is the most significant African-American actor in cinematic history, and you also have to think about him as being the oldest. He was the oldest living Oscar winner. So he is the one connection he was one of those connections that we had to the golden age of cinema. He really was a man who changed the way that Black people looked at themselves when they saw him and what he did on screen.
Kevin, Poitier, as we've said, became the first Black performer to win an Academy Award for Best Actor at a time when segregation was still legal in the United States. How groundbreaking was it when he won his award? And how do you think it changed the landscape of entertainment moving forward?
Well, you know, I talked to Oprah Winfrey about that moment, and she talked about being a little girl sitting in the segregated South, watching that moment and watching this Black man walk up and receive that Oscar. And she says it was so profound. It was so mind blowing. And at that moment, she realized that she could do anything. And that's the thing. And you also think about, you know, the roles he played, what a pivotal year 1967 was for those 3 important roles and those 3 important movies he played. Guess Who's Coming to Dinner, the Heat of the Night, and of course, To Sir with Love. And if you remember The Heat of the Night, he is a detective from Philadelphia coming down to investigate a situation in the South, and he's dealing with a small town Southern sheriff, and the Southern sheriff smacks him, and he smacks him back. And at that time, you hadn't seen a Black man challenge a white man like that. And also when he tells Carol O'Connor in that movie, "You call me Mr. Tibbs." It's just a seminal moment. And then you turn around to Guess Who's Coming to Dinner. And here's this elegant doctor who is now engaged to a white woman and her family trying to digest what's happening. It was just these roles that changed the way that African Americans were looked at. And that was who Sidney Poitier was.
He had such a legacy. And Kevin, you touched on this a little bit, but if you can tell us a little more about how Poitier used his platform to champion civil rights.
Sure. You know, the civil rights movement, while so many people were a part of it, it needed money, and it needed people on large platforms to champion it. And that's where Harry Belafonte, Sidney Poitier, those folks stepped in to help fund those moments and also to lend their voices to other people who might not have listened initially. You need star power when you're trying to change the world. And Sidney Poitier wasn't afraid to step to the forefront and say, I am challenging these people, their way of life, and the laws of the land right now. And I'm also willing to put my money where my mouth is. And you saw it throughout his life and his career. I mean, let's not forget, he was the ambassador to Japan for the Bahamas. Throughout his life, he did things that were groundbreaking and different, and you wouldn't have expected for a man who came from the Bahamas and was a janitor when he first got here to the United States. But when you talk about the civil rights movement, and it is very clear, if you ever watch the documentary Eyes on the Prize, without Harry Belafonte, without Sidney Poitier, the civil rights movement might have run out of money.
What an incredible man, and what a legacy. Kevin Frazier, by the way, nice to meet you virtually, and thank you for your time.
Nikki, great to meet you, and he was an incredible man who changed the world. He will be missed, but never forgotten.
Thank you. We want to head back to Brunswick, Georgia, where the sentencing hearing is back underway for the men convicted of killing Ahmaud Arbery. Let's listen.
Could impose sentence anyway without that notice. And that would require the courts resolving two competing statutes. You have the sentencing statute itself, and then you have 1716-4, under which the notice was provided. We would suggest a rule of lenity indicates that where the notice has not been served, or there's not proof of proper service, that the court doesn't have discretion to impose a sentence of life without parole. I'll let the court think about that. It may be an academic question anyway. Particularly given the state's recommendation, which we're certainly not going to disagree with. But going beyond that issue, Your Honor, while Mr. Bryan is also a first offender and also worthy of rehabilitation based on the life that he's lived, as the evidence reflects, that's where the similarity between Roddie Bryan and the McMichael defendants ends. And I would submit to the court that isn't the beginning of the sentencing inquiry for Mr. Bryan, the end of the sentencing inquiry for Mr. Bryan. I would respectfully submit that it's the beginning. Now, before getting into that, I do want to address one other, lawyers probably shouldn't use the word technical arguments, but I would contend that count 9 merges into count 8. I don't think alleging separate streets that the chase is occurring on changes it. If someone was chased through the city of Savannah, I don't think that you could argue that there were 15 different attempts at false imprisonment or 15 different false imprisonments. If you went down Montgomery and up MLK and across Broughton and up the President and down Julian, I don't think you could multiply counts that way. I do think that 9 is an inchoate offense that obviously merges into 8. And because the motor vehicle that was used in this case was used in the context of the chase, there's a factual merger. And I think it's more or less the same argument that Ms. Hogue was making, but I could be mistaken. And so I want to adopt her argument as well, to the extent it's expansive beyond mine, and specifically a recitation of the Knoll and the Hewlett cases. Having done that, I want to get into what I think is where the sentencing inquiry for Mr. Bryan really begins, because this is a kind of unusual case. To me, there are 4 additional factors that the court has to consider in fashioning a sentence here. And then the question becomes how the court does that under the laws of our state. We've already challenged those laws. The court, not surprisingly, given prior decisions of our Supreme Court, whatever standards may be evolving until the Supreme Court says they have, this court applies the law that we have. But there are 4 factors here that I think the court has to the court never has to consider anything I think the court should consider. Issue number one is the jury verdict says that Roddie Bryan was not a party to the shooting, nor a shooter. Roddie did not kill Mr. Arbery. He did not attempt to kill Mr. Arbery. He did not intend to kill Mr. Arbery. He had no idea that the McMichaels had guns until moments before the shooting. And that's not just an opinion, that's pretty much the jury verdict. When they acquitted Mr. Bryan, not only at count 1, but also count 2 and count 6, when they found him not guilty of anything related to the shooting, that's a reflection of the fact that Mr. Bryan had no idea of what was about to happen. That tragedy was certainly not something that he could have anticipated up until the moments before. And by saying that, I'm not trying to get back into the charge conference issues. It's a different factor here at sentencing. But Roddie Bryan was not a vigilante. He was not a party to any organized effort to fight crime in Satilla Shores. Roddie Bryan really had no idea what was going on or why until after the tragic death of Mr. Arbery. And I think the state pretty forcefully drove that issue home during its closing argument in this case. That factor really puts Mr. Bryan in a different position. Mr. Bryan isn't the one who brought a gun. He was unarmed. And I think that reflects his intentions and it reflects a significantly lesser state of culpability. The second issue, Your Honor, is the issue of remorse. Now, like the McMichael defendants, Mr. Bryan faces a federal trial and substantial federal penalties in the event of a conviction. I would agree with Mr. Rubin that no competent attorney in the state of Georgia under these circumstances would allow a defendant to say anything more than they already have. But in this case, distinguishing again Mr. Bryan from the McMichael defendants, Mr. Bryan has expressed remorse. Whether it's part of the record or not, he expressed remorse about Mr. Arbery's death even before he was arrested on national television. As the Arbery family, of course, has not accepted that, and they don't have to, Your Honor, and we can all understand why. But beyond that, when you look at his statements in this case, I think it is readily clear that while Mr. Bryan has disputed and continues to dispute whether things that he did that day constituted crimes, he has never questioned the tragedy of this death and has never expressed anything but remorse over the death of Mr. Arbery. And that does put him in a very different category, I would submit, in a very different posture from the other defendants. And I would remind the court, and I'm not going to spend a lot of time on it because the court heard most of this, but during the trial, the court heard the body cam from Mr. Minshew. Mr. Bryan admitted from the get-go that he chased after Mr. Arbery, that he was uncertain as to whether they should have done that. He wasn't running around the scene trying to influence witnesses' testimony, as the state alleges other people have done. He was very candid and straightforward, and you heard his demeanor on the video at the crime scene. You heard the excerpt from the interview with Detective Lowry, and of course the court has the entire statements in the record, where Mr. Bryan expressed, again, regret that Mr. Arbery died. He pointed out that, if his vehicle had collided with Mr. Arbery, maybe Mr. Arbery would still be alive. And not in the context of wanting to hurt Mr. Arbery, but in the context that maybe he would still be with us. And this tragedy might have been something less. Beyond that, Your Honor, there were a number of statements made to investigator Sechrest, Special Agent Sechrest, during the investigation of this case, which technically, I believe the statements themselves, the transcripts and the videos were admitted into evidence at the Jackson v. Deno hearing. At least that's my practice. I don't have a transcript to look at, but that's normally what I do. And moreover, I think they were tendered in connection with the preparation for the trial itself, and I think technically during the trial, they weren't presented to the jury, but the court can consider those. On May 11th, Mr. Bryan, I'm referencing page 69 of that transcript, indicated that he did not want to see the video in the aftermath of the shooting. He didn't enjoy it. He didn't take any pleasure in that. On May 13th, at page 75, Roddie Bryan expressed shock to Agent Sechrest at the shooting of Ahmaud Arbery. Referencing page 100 of the transcript, Roddie thought it was that what Mr. assumed, thinking might be putting too much credit to Mr. Bryan, Roddie Bryan assumed that Mr. Arbery had done something more serious, that there was more to it than going through an open, unsecured construction site. And that doesn't change the lawfulness or unlawfulness of his conduct, but it does reflect on his level of remorse. At page 101, Mr. Bryan says that to Agent Sechrest, and these are all statements that the state could have used at the trial against him had they wished to do so, and may still be used against him in federal court. None of these statements are without consequence. That he was sorry that Ahmaud Arbery died, that he wished he had stayed on his front porch. He's not going around boasting to people or bragging about it. He's regretful way back then. And that is before he was arrested. At page 102, he regretted having got involved in the chase. And, Your Honor, I think when you take those statements in conjunction with the rest of the evidence in this case, Mr. Bryan has done everything he could do, short of confessing to committing felonies on national television, that he is remorseful and regretful at this tragic loss of life. And it's difficult for me to conceive what more he could do. Now, is the Arbery family going to be satisfied with that? No. They don't have to be satisfied with that. You have to give credit. 3 members of his family came up here and probably did what were the most difficult things they've ever had to do, is to come speak here in this court on national television effectively about the death of their child and their brother. And that's difficult. But whether or not they accept Mr. Bryan's expression of sorrow and remorse for the death of Mr. Arbery, it's for the court to decide whether Mr. Bryan has expressed remorse, and if he has, what to do about it. And the court may well decide there's nothing the court can do about it. The felony murder statute prescribes one punishment, a mandatory minimum of life. And I'm not reviewing the legal argument there. But if there's a way the court can take it into account, I'm going to argue that the court should. The last issue, Your Honor, and I think the court is well familiar with it, is Mr. Bryan's full cooperation with law enforcement from day one, from moment one, from minutes after the shooting. I'm not going to belabor all the different things Mr. Bryan did, producing the cell phone, the night out video, the numerous statements, going through the area where the shooting took place with the police to help them understand what happened that day. On a scale of cooperation, you'd have to put Mr. Bryan at a 10 out of 10, even a 12 out of 10. I've never seen a defendant provide that kind of cooperation. Most of it without the benefit of counsel. Slick lawyers didn't tell Roddie Bryan to turn over the cell phone, to talk on the scene on the body cams, to go down hours later to the police department. Roddie Bryan did that because he wanted the truth to be known, whatever that was, whatever it meant. So these are all factors above and beyond anything that apply to the McMichael defendants as to why Mr. Bryan should receive a lesser sentence. Now, the mandatory minimum in Georgia is life imprisonment on a felony murder. I'm not going to rehash the legal arguments. What I am going to suggest to the court, though, and given the age of the defendants here, whether Mr. Bryan is eligible for parole or not, he's going to be 80 years old under the current guidelines before he could be eligible for parole. And effectively, even if the court grants life without parole sentences, as the state has requested, to the McMichaels, simply giving Mr. Bryan a sentence of life with the possibility of parole, still, given the respective ages, means that he would essentially serve the same sentence and that there would be no options there. So I'm asking this court to consider sentencing Mr. Bryan and Mr. Bryan only under OCGA 17-10-1B, which, at least in my experience, is relatively rarely employed, but perhaps underused, especially given the evolving standards of, with respect to sentencing issues. Under 17-10-1B, as I understand it, a request for relief from parole restrictions may authorize consideration by the parole board of parole prior to the completion of any specified time period otherwise required prior to parole eligibility. Imposing sentence under this statute does not grant Mr. Bryan parole. He still may never receive parole. He could still die in prison 50 years from now, even if the court grants relief under 17-10-1B. All that does, however, is it gives the parole board the freedom, if you call it that, the ability to parole Mr. Bryan whenever they see fit, regardless of any statute or rule that would otherwise prevent it. Now, Mr. Bryan still has a long road here to establish the redemption and the rehabilitation that would justify his ever being released from prison. So, as I've explained to Mr. Bryan, this doesn't guarantee him that he would do 1 day less in prison than he would otherwise do under the sentence that the court is about to impose. But what it does do is provide the opportunity for the parole board to exercise its discretion in deciding whether to release Mr. Bryan when they believe it would be appropriate and not based on some arbitrary, preconceived, mandatory minimum time period before he could be considered. And I believe that this is that rare, exceptional case where relief under 17-10-1B, however fleeting it might be, depending on the circumstances, that this is a case where that would be appropriate. And I would respectfully submit to the court that as a practical matter, it is the only, it's really the only relief that the court can give Mr. Bryan to reflect his cooperation, his expression of remorse, and the other factors that I've reviewed with the court today. And that doesn't change the sentencing recommendation. I'm concurring with the state, putting aside the legal arguments about merger and vacating of sentences. I'm agreeing with them that the sentence of life plus 15 consecutive probation, that would be the appropriate sentence in this case. I think the only thing that we really are disagreeing about at this point is I'm expecting the state is not going to be excited about 17-10-1B, but I'm asking the court to do that anyway. And in this relatively small instance, and again, it may be completely meaningless depending on how the parole board views things 10 and 20 years down the line, but it is really the only thing short of striking down parts of Georgia's sentencing law on constitutional grounds. It's really the only thing this court can do that would substantially reflect the wide chasm in differences in culpability and other issues between Mr. Bryan and the McMichael defendants. It's really, it's all that this court really has available to do that. And if for no other reason, that's why I would ask the court to do so. But I do think it would be in the best interest of justice. I mean, Your Honor, Roddie Bryan probably, I won't say he's unique, but he's pretty as close to unique as you can get in our criminal justice system. It's a felony murder for someone who didn't kill or attempt to kill or intend to kill, and it's in the context of a citizen arrest, however foolish and badly guided and misinformed, and certainly however unjustified under the law. There probably isn't another individual in the entire Georgia prison system that's in a similar posture, and thanks to the changes the legislature has made to the citizen arrest statute, it will certainly never be an issue again. So this is a request that we're making here on behalf of Mr. Bryan that would effectively impact one person now or in the future in the state of Georgia. And we're not asking that as special treatment for Mr. Bryan. We're asking it as treatment that anyone in his situation would be asking for, given the totality of circumstances present to the court. So again, we're asking the court to impose a sentence of life imprisonment plus 15 years. But we're also asking the court to grant relief under 1710(1)(b). Thank you, Your Honor.
Thank you, Mr. Goff. From the state.
Thank you, Judge. Because there's a number of legal issues as well as additional argument by the state, is there any particular order you'd like to hear it in? Would you like me to start with Mr. Bryan first and work backward, or just go from Travis and...
Why don't we, however the state wishes to present it, I'll be able to follow it, I would imagine.
Wonderful. Okay, Judge. So regarding Mr. Bryan, with regard first to this parole board issue, 1710(1)(b) actually says that it will apply only to first offenders, where technically Mr. Bryan is a first offender. He doesn't qualify under the first offender statute because anyone convicted of felony murder, you're not allowed to sentence them under the first offender statute. So we have that problem first. But the second problem is that it refers back to A. And subsection A of 1710(1) actually says, except in cases in which life imprisonment, life without parole, or the death penalty may be imposed, and then goes through. So B can't even apply to anything that imposes a life sentence. And that's how the state is reading this, because when you look at B, the judge, in fixing the sentence as prescribed in subsection A of this code section, subsection A says except for life sentences. So therefore, none of this will ever apply to a felony murder conviction. And then looking at count 9 merging into count 8. I understand factually the issue that Mr. Goff has brought up on behalf of Mr. Bryan, that two separate instances, one an attempt to confine him taking place on Burford, was just a continuation of something that was going on and on and on and on. Ironically, that was not the argument that Mr. Goff made at trial during his closing argument. He actually started to posit that Mr. Bryan was actually leaving and wanting to go home and just happened to go in the wrong direction back down Holmes, and that he wasn't actually trying to commit a false imprisonment on Holmes. He was just trying to go home. But regardless, what we have here is an intervening factor. I didn't know Mr. Goff was going to make this argument, but I believe there's a case out there that involves aggravated assault and aggravated battery. And it involved a man who had cut the female victim's throat and then also cut her face. The aggravated battery was on the face, the aggravated assault was on the throat, but there was an intervening time frame. And so on the one hand, I do know that there are numerous cases out there where if you start shooting at somebody and then continue to shoot, it's all one aggravated assault. Okay, there aren't separate aggravated assaults for each time you fire, unless there is an intervening actual time frame where you've shot, they've run away, you've chased them down, and now you're over on another street, like we have in this case, you've encountered them again, and now you start shooting again. Because there's two different locations, two different specific places and times, that allows the state to charge it. And the reason it allows the state to charge it is because what you're really trying to do is prevent the state from engaging in double jeopardy. You don't want the state to be able to go on January 3rd on Burford, no, on, well, I'll do our case. On February 23rd, 2020, on Burford, you attempted to falsely imprison him. Oh, not guilty. Okay, well, we'll go ahead and move it over to Holmes, and we'll get a new indictment, and we'll do it over there on that date. So you want to keep the state from going ahead and doing two different things in two different bites of the apple. You want to make sure there's no double jeopardy here. Well, in our case, we don't have double jeopardy here because we have two different separate instances, and they're both in this indictment, and they're both two separate time frames. Yes, very close in time, between 4 minutes. I know I'm kind of giving the court both the defense side and the state side, but to be candid with the court, there are cases out there, especially the gunshot cases, that say it's all one continuous action. The state's position in this indictment, and one of the reasons we specifically indicted it this way, is because Mr. Bryan's attempt at false imprisonment on Burford was specifically done with his pickup truck when he tried to run Mr. Arbery off the road and tried to attempt to falsely imprison him right there with his truck. He attempted 4 different aggravated assaults on him at that point in time to get him to stop there. He was unable to do it. That's why it's a criminal attempt. However, over on Holmes, after he went up and chased him up, and then we begin the video, and Mr. Arbery turns back, Mr. Bryan does continue to go up Holmes. He actually goes up Holmes. It's on video. He pulls into a driveway. He says, I'm going to go ahead and keep going. He does a 3-point turn, and then he comes down Holmes. He encounters then Mr. Arbery coming around the corner, and that is where that actual false imprisonment absolutely takes place, right there on Holmes, where Mr. Arbery is ultimately falsely imprisoned and killed. So these are 2 separate, distinct incidences, and there is no chance of double jeopardy because both of these things are distinct. They took place at separate places and separate time frames within the incident. So we ask that count 9 not merge into count 8 for Mr. Bryan.
I'm sorry to interrupt. I'm not sure because of the way we're doing this. I did want to point to the court to another case with respect to this issue that's been drawn back to the merger issue that I raised, and that is the point is whether or not it's a continuing offense. Kidnapping is a continuing offense. So, for example, if someone is moved, an asportation occurs, all the places during that movement are one crime. And I'll cite to the court Hill versus the state, 279, Georgia App 666, a 2006 case that's cited in Brower versus the state, 298, Georgia App 699, a 2009 case. It says that the offense of kidnapping is complete when, in this instance, Brower seized the victims, forced them to the back office in the case of the office staff, and when he taped up and moved the attorney from place to place in the office. So the movement is the question is, if kidnapping is not a continuing offense, then is false imprisonment, and I've done a search and I just don't have the answer to that.
And, we'll keep the state to its argument. Understanding that with the kidnapping, the issue here I think is slightly different. As I understand what the state's arguing is the way that false imprisonment and the attempt was alleged in the indictment was that the attempt occurred on Burford. There was an intervening interval, and then later, short period later, but later, there was a completed act on Holmes. Okay, that's the argument that I understand is being presented, and that's the way I'm going to look at the merger part of it. Now, how that fits and whether or not it merges, I'm probably going to take a few more moments to think that through and how that works. But that's what I understand we're looking at as far as the legal issues. I understand the kidnapping part of it. You have a kidnapping, just because you move them within the office, we're not going to allege it. Flip side of that is, I mean, you look at some other statutes like I won't tip at windmills, but when you look at police chases, I mean, you can be charged with obstruction 5 times in the same chase. So, I mean, the issue may seem simple, but it's not. But this is the way I'm going to approach it. Okay.
Thank you, Judge. And I believe the reason for the merger really comes down to the issue of double jeopardy, because you have to put the defendant on notice, because you do not want there to be an opportunity for the state to come back with double jeopardy, which is why you want to get as specific as possible, and which is what we did in order to designate these 2 separate instances in time and in place. So that is the state's argument as far as count 9 merging into count 8. And that is what I have for Mr. Goff. Now, Your Honor, with regard to the legal argument that Ms. Hogue made on behalf of Greg McMichael, actually, Noel was then cited in the case of Jeremy Scott, who killed Dexter Holliday. It was a Fulton County case. Embarrassed to say it was my own. And in that case, we had to resentence Mr. Scott because what the court did was sentenced him on the felony murder conviction, but then actually when he was found guilty of possession of a firearm by a convicted felon, The court went and took the possession of a firearm by a convicted felon, merged it into the felony murder, then merged the felony murder into the felony murder for the armed robbery. And the court went and cited to Noel. And this is Scott versus the state, 302 Georgia 29. It's a 2017 case. The state notes that, based on Noel versus the state, the trial court erred in merging the felony murder convictions and then merging the predicate felonies into the remaining murder conviction. When the trial court sentenced Scott on count 2, the felony murder based on aggravated assault, count 3, felony murder based on possession of a firearm by a convicted felon, was vacated by operation of law. Therefore, count 6, possession of a firearm by a convicted felon, then cannot merge into count 3, which stands vacated. We therefore vacate the merger of count 6 into count 3, meaning the possession of a firearm by a convicted felon, into the felony murder that it's based on, and remand for resentencing on count 6. Now, factually, you are a convicted felon at the moment you're shooting that person. It happens at the exact same time. So I think that kind of goes towards that, well, if it's all happening at the same time, it needs to merge together. And I will also direct the court to a case I affectionately call the El Camino case. Once again, unfortunately mine. This is DeMarcus Graves. It is Graves versus the state, 298 Georgia 551. Once again, a 2016 case. And at that point in time, basically it said, while the evidence was sufficient to sustain Graves's conviction, we find an error in sentencing. The trial court purported to merge 2 felony murder counts with the malice murder count. The trial court then purported to merge 2 independent felonies, criminal attempt to commit armed robbery and possession of a firearm by a convicted felon, with the 2 murder counts. And basically what they said in Graves was, no, you can't merge the felony murders into murder. You have to vacate them by operation of law. And once they're vacated by operation of law, that's going to leave you with the possession of a firearm by a convicted felon and the criminal attempt to commit armed robbery. Therefore, the trial court is required to vacate that portion of its sentencing order purporting to merge the 2 independent felonies and impose proper sentences on those counts, which I then had to go ahead and do and resentenced Mr. Graves to the murder charge with those 2 particular felonies. So there are 2 cases right there that show that that is not the case, because they murdered Mr. Graves while attempting to rob him of his drugs while he was sitting in his El Camino in the parking lot of an apartment complex while being convicted felons. All of that took place at the exact same time. So therefore, Noel does not stand and has been overruled basically by Scott and Graves. So with regard specifically now to Greg McMichael, the idea that there was no vigilantism here because after they confronted people, after they took their guns to confront people, after they confronted those people with those guns, then they would call the police, is somehow a neighborhood watch situation. As Officer Rash testified, there's supposed to be witnesses. That's what neighborhood watch is there for. They're supposed to be great witnesses. Officer Rash said he thought Greg McMichael would be the best witness, being a prior law enforcement officer, that he'd be able to come in and take the stand and say what he saw. That's what neighborhood watch is supposed to be, not somebody running after people in a residential neighborhood where there are women and children and people out walking on a regular basis. This was a Sunday afternoon. It's a miracle they didn't run into families taking a walk that day. And on a random day, when the GBI went out with the drone videos and were just going through the neighborhood, they captured numerous people out taking a walk. A family with children were there. So the next point, that Greg McMichael has shown no remorse or empathy because he's unable to. Well, Greg McMichael was a law enforcement officer. But what he did on May 5th of 2020 was release evidence in an ongoing investigation into himself and to his son. Greg McMichael's the one who released the video to the media. He went to Mr. Bryan and said, hey, give me your phone, I'm going to take it to my lawyer, took it to his lawyer and had his lawyer release it publicly because he believed it was going to exonerate him. That's interference with administration of justice. Yes, we did not charge him with obstruction or anything like that. But the fact of the matter is this is someone who was in law enforcement for years and actually actively pursued evidence in a case against him to be released to the media because he believed that that video showed he and his son were not guilty of anything. That's 2 months afterwards. The state's position is he hasn't changed his mind. The state's position is he and his son still believe they didn't do anything wrong. And that is a lack of remorse or empathy. The idea that he did not intend the death of Ahmaud Arbery, once again, he's a law enforcement officer, got a gun, went running after somebody. The jury did find that he intended to commit false imprisonment, criminal attempt at false imprisonment, aggravated assault with that pickup truck, and aggravated assault with that shotgun. And we all know that felony murder has a foreseeability component to it. Ahmaud Arbery's death was foreseeable, and especially foreseeable to someone in law enforcement. The idea that they wanted to get to the bottom of what an unknown person was doing in some neighbor's house, a neighbor they didn't even know, goes back to our vigilantism. This whole idea that they were trying to help the neighborhood out has been an excuse from both Travis and Greg McMichael. Ms. Hogue got up here and said, this wasn't advancing the progression of the crime. And I apologize for this once again, Your Honor, but stop or I'll blow your fucking head off. I think that really advances the progression of the crime. You're threatening to murder somebody. You're threatening to kill him if he does not stop. And referring back to the post records produced in the bond hearing, Greg McMichael was so not paying attention to his job as a law enforcement officer that he was not post-certified from January of 2006 through 2014. He was an investigator in the district attorney's office, and he let his post-certification lapse from 2006 to 2014, 8 years. I won't even go into what that could have meant to those cases that were prosecuted by the district attorney's office. He then lost the post-certification again in 2018, and Jackie Johnson had to make an accommodation and change his designation at his job just so he could keep his job through retirement. This attitude of I'm special and I'm above the law and the law doesn't apply to me and I can take my gun and I can run after people and confront the homeless guy under the bridge and then call the police later about it. That's vigilantism, and that is the main reason. The thoughtlessness, the remorselessness, the desire so to be special and protect himself and his family by taking evidence and releasing it publicly when he knows there's an ongoing investigation is the reason we are asking for life without the possibility of parole. And with regard then to Travis McMichael. There's a reason, Your Honor, you did not grant bond to Travis and Greg McMichael. Mr. Rubin went back to all of those things listed in the bond hearing. The state will also direct the court to things the state presented in the bond hearing, including his text messages with all of his offensive racial animus and language. The jury did find that he had an abandoned and malignant heart. That's exactly what the jury found. They were given that he intentionally went ahead and did this, or the other level, abandoned and malignant heart. In addition, I will remind the court that there's an old saying, the road to hell is paved with good intentions. And it's great that they had such good intentions to protect the neighborhood. But the thoughtlessness, the lack of vision to know how this could go terribly, terribly wrong. And the fact of the matter is, Your Honor, it was a year and a half. February 23rd, 2020. November 2021, Travis came in here and testified. The state asks that you take into consideration his demeanor, his attitude. He said, this was the worst day of my life. Well, how'd that work out for Ahmaud Arbery? Not once did he show any empathy or ability to place himself in the position of Mr. Arbery on the stand. And yes, 4 minutes of conduct. Well, 4 minutes of conduct. Usain Bolt won 8 gold medals. When he runs those races, they're less than 2 minutes long. But the reason he's able to do that, the reason he is able to win, is because of 20 years of training that leads him to those 2 minutes. Those 4 minutes are a reflection and a result of an entire lifetime of Travis McMichael and his attitude, his demeanor, what he believes he's entitled to go ahead and go do. The same applies to Greg McMichael. That 4 minutes of conduct wasn't just 4 minutes of conduct. It was a culmination of vigilantism. We get to go ahead and play law enforcement even though we're not, and that we're going to go out and confront people, and we're going to take our guns to go do it without any real understanding or consideration of the consequences. At this time, for Travis McMichael, these are the reasons that we are asking for life without the possibility of parole. Thank you, Your Honor.
All right. That being all argument and evidence presented, and I say that just to be clear on the record, there had been some discussion with counsel about evidence and the record. The court is going to leave the record open, as I understand it, for what's going to amount to a notice of filing and 2 affidavits, just in order to preserve arguments made during the trial on appeal. I'm going to take about 10 minutes, maybe 15 minutes, and go through my notes, and then the court will pronounce sentence. We are in recess for 15 minutes.
We've been watching the sentencing of the 3 men convicted of killing Ahmaud Arbery. The family of Arbery spoke before the sentencing, asking for the maximum sentence. But they said no matter what, nothing can bring back the 25-year-old. We'll be right back after a quick break.
I'm Norah O'Donnell in our nation's capital. We're here at the White House with the President of the United States.
Thanks for having me. I appreciate it.
The Supreme Court building behind me is once again at the center of a monumental battle. Tonight, a congressional investigation sparked by reporting from CBS News. Our exclusive access to the presidential platform. We will witness yet another moment in history.
The CBS Evening News with Norah O'Donnell from Washington, D.C. An original documentary on CBSN.
50 shows running, the lights blinking.
People fight their entire career to get to Broadway.
You've trained your entire life.
Spotlights, drama, passion.
This is what we live for.
Until COVID turned off the lights.
It's like going from a bright light to pitch black.
Scenes from Broadway's unique struggle with COVID.
It was devastating.
Broadway contributes about $15 billion to New York City's economy and 100,000 jobs.
The sound team, the lighting team, everyone.
The world does not realize how big this is.
This is how we make money.
This is a specialized industry. You don't tell a doctor to go get a serving job. Why are we different?
Are we going to be able to pay our rent? Am I going to have food?
What will happen in Broadway's new opening act?
We're in uncharted waters again.
The show must go on.
There is reason to hope again.
I think people are going to be crying. I know I will.
An originals documentary on CBSN. Stream now.
Welcome to CBS Mornings.
Up next, stories you'll be talking about today. That's a big deal.
People stop me on the street and say, I always learn something new every day when I watch your show.
This morning, we're going to begin with some good news.
Oh, you just put me in a good mood.
Just follow me. I'll lead the way.
There's always something new under the sun. CBS Mornings, weekdays on CBS.
The Supreme Court will decide whether 2 of the Biden administration's vaccine rules can move forward. This as we receive new guidance about shots and boosters. The 3 men convicted of killing Ahmaud Arbery learn their fate today. We'll bring it to you when it happens. And a blast of winter weather smacks the Northeast, canceling flights, tying up roads, and knocking out power. Hi, everyone. I'm Nikki Batiste in for Tanya Rivero. Thank you for joining us. Also this hour, quarantine drama down under. The new stance from the Australian government as Novak Djokovic waits to learn if he'll be able to leave a hotel room and get on the court. And fears of a twin-demic. Doctors warn some people are coming down with COVID and the flu at the same time, and how they say you can avoid it. More than 300 million COVID cases have been reported worldwide since the start of the pandemic. As the U.S. continues to fight its biggest surge yet, the FDA is pushing for more booster eligibility. People will now only have to wait 5 months to receive a third dose of Moderna's vaccine, as opposed to 6. Meanwhile, growing concerns forced Chicago public schools to cancel classes for a third day. City officials and the teachers union are clashing over whether or not it's safe to continue in-person classes as Omicron cases surge. In Washington, a Supreme Court showdown is underway over the Biden administration's vaccine policies. Justices are hearing arguments focusing on COVID rules for larger companies and certain healthcare workers. Skylar Henry has more.
The Supreme Court heard arguments this morning on 2 challenges to the Biden administration's vaccine and testing mandates. The rules issued by the Occupational Safety and Health Administration would require businesses with 100 or more employees to be vaccinated or get tested weekly. The other rule from Health and Human Services would require healthcare workers at facilities that receive Medicare or Medicaid be fully vaccinated. Conservative groups are challenging the rules.
OSHA's economy-wide mandate would cause permanent worker displacement rippling through our national economy, which is already experiencing labor shortages and fragile supply lines.
Justices question why the rules shouldn't stand.
It's obviously the policy that's geared to preventing most sickness and death.
And they questioned why the court should immediately block the rules from taking effect.
The short version is, as soon as businesses have to put out their plans and this takes effect, workers will quit.
I would find it, unbelievable that it could be in the public interest to suddenly stop these vaccinations.
The arguments come as the Omicron variant is sweeping the country, leading to record numbers of new COVID cases each day. Friday morning, the FDA announced people 18 and older with the Moderna vaccine need to only wait 5 months before getting a booster. They said vaccination is our best defense against COVID-19, including the circulating variants, and shortening the length of time between completion of a primary series and a booster dose may help reduce waning immunity. And the Biden administration says it's finalizing plans to ship 500 million COVID test kits directly to Americans' homes. Skylar Henry, CBS News, the Supreme Court.
The teen accused of killing 4 fellow students at a Michigan high school in November has waived his right to a preliminary hearing, paving the way for his trial. 15-year-old Ethan Crumbley virtually appeared in court after entering a not guilty plea. He's facing a list of charges ranging from terrorism to murder. His parents are also in court today asking for a lower bail. They're charged with involuntary manslaughter after prosecutors say they failed to secure the gun Ethan used during his deadly rampage. They've also pleaded not guilty. And sad news out of Hollywood. Legendary actor and director and activist Sidney Poitier has died. Poitier was the first black performer to win an Academy Award for Best Actor. He was 94.
Well, you're pretty sure of yourself, ain't you, Virgil? Virgil, that's a funny name for a boy that comes from Philadelphia. What do they call you up there?
They call me Mr. Tibbs.
Poitier was considered a trailblazer during the civil rights movement. Former President Obama awarded Poitier the Presidential Medal of Freedom in 2009 for his impact on American culture. Michael George has more on his life and legacy.
Sidney Poitier was an award-winning actor, but also played the role of a Hollywood trailblazer. He was the first prominent black movie star, and he didn't shy away from roles that took on the issue of race.
Come on. Why you black? Go ahead and say it.
Poitier was raised in the Bahamas on his father's tomato farm. He quit school as a teenager and eventually landed in New York, where he found work as a dishwasher. His first acting audition was at the American Negro Theater, but the producers laughed at his accent. Undeterred, Poitier worked on his speech for months and eventually made it to the stage.
All right, let's get them in there.
In 1950, he got his big break in Hollywood and soon rose to stardom as a dramatic leading man.
But you think of yourself as a colored man. I think of myself as a man.
In 1964, he became the first African American to win a Best Actor Oscar for Lilies of the Field. That was followed by a string of hits, including his role as the fiancé of a white socialite in Guess Who's Coming to Dinner.
Mom, this is John. He thinks you're gonna faint because he's a Negro.
I'll take that.
And his legendary role as Detective Virgil Tibbs in the Heat of the Night. In the 70s, Poitier started working behind the camera, splitting his time between directing and acting for the next 3 decades. In 2002, he was given an honorary Oscar for his life's work. That same night, African Americans won for both Best Actress and Best Actor.
I came here at a time when this Hollywood that you know was not the Hollywood here when I arrived.
And in 2009, the actor who helped bridge America's racial divide received the Medal of Freedom from America's first black president. Michael George, CBS News.
The U.S. labor market experienced an unexpected slowdown heading into the new year. The U.S. added a disappointing 199,000 new jobs in December. That's less than half of what economists were projecting for the last jobs report of the year. President Biden, however, is praising his administration's economic recovery efforts in 2021, despite last month's limited job gains, after the unemployment rate fell to its lowest point since the start of the pandemic.
Today's national unemployment rate fell below 4% to 3.9%, the sharpest one-year drop in unemployment in United States history. The first time the unemployment rate has been under 4% in the first year of a presidential term in 50 years. 3.9% unemployment rate. Years faster than experts said we'd be able to do it. And we have added 6.4 million new jobs since January of last year, in 1 year. That's the most jobs in any calendar year by any president in history.
Diane Swank is the chief economist at Grant Thornton. She joins us now with more on this. Diane, this was the Labor Department's final jobs report for 2021. What do these numbers reflect about the U.S. economy heading into the new year?
Well, really, it reflects sort of this wormhole that we've gone through as a pandemic. We've seen job openings soar, even as the number of people looking for workers has fallen relative to those job openings. The participation rate has picked up, but it's not picked up as much as we'd like. And we know, things like child care, people out ill. We also saw a number of people who are absent from work and due to illness pick up during the month. That's all complicating the supply of labor, along with long COVID and a loss of immigration. What it's given us is this red hot labor market where wages are soaring. That's terrific news. Of course, if it's not enough to compensate for inflation gains out there, that gives people another setback. And one of the other interesting aspects of this report is that as employers were looking for workers and raising wages, which is great news for workers, we also saw those workers taking multiple jobs pick up. We hadn't seen that happen in a long time, and that's important too, because I think it reflects this sort of this really hot situation we're in that's not all about wages. Unfortunately, it's about prices as well. And many workers, although they're getting boosts in their low-wage jobs and they're seeing wages accelerate and those wage gains are becoming more broad-based, that's great news. But if it doesn't compensate for the rising prices of things they're paying every day out there, most notably at the gas pump and in grocery stores, that really cuts back into it. And I think some of the multiple job holders is a sad commentary on that, and why the Federal Reserve sees this as full employment, even though we're still 3.6 million away from where we were back in February of 2020.
Yeah, those gas prices are really hurting our wallets right now. Unemployment fell to its lowest point since the start of the pandemic, despite the fact that the Omicron variant is causing severe staffing shortages nationwide. Omicron, of course, was only first reported in the U.S. at the start of December. So is this data reflected in last month's job report, in turn contributing to the slowdown in hiring? Or is this a larger problem that we could see reflected in next month's job report?
Well, it's really more of a January problem. Didn't show up in this survey week. This was really done in early December. And even though it's mid-December report, the survey was conducted earlier in December before we really started to see the full effects of Omicron. And we're really starting to feel that bite now. Chicago Public Schools being set back. That's going to be a huge setback to parents wanting to participate in the labor force. We're seeing many businesses close. Those workers are not going to get paychecks in the month of January, or at least for part of the month of January during the next survey week. And the number of people who are absent and out due to illness, that did continue to rise with the Delta wave in December. Now we're seeing Omicron overshadow that, and the numbers explode. And so I think January is going to be a really tough month. I wouldn't be surprised to even see a negative print in the month of January as we get that setback. The only silver lining to this variant is how rapidly it ascends and descends. It does seem to peak quickly, and we're hoping that, looking at New York and London and places that it's hit before us, South Africa, that we'll see it recede much more rapidly than we saw other variants recede, with hopefully lesser effects for those people who are vaccinated out there.
Diane, I know this is tough because COVID is so uncertain, but can you give any projection of what 2022 might look like in the jobs market, where we may be as we head into 2023 next year?
I think we're going to be in a place by the end of next year that we will have exceeded that previous peak in employment, and unemployment rate will still be even lower. We are going to see some comeback in participation over the course of the year, and I think that's welcome news for those workers who have been sidelined by COVID. I do worry about long COVID and how many workers we have that have to go on disability as a result of this pandemic. The health of the economy is ultimately dependent on the health of the overall population and our workers out there. And I do worry about some of the scarring that we have due to COVID. Although the overall economy, the aggregate numbers will look good, they'll mask some of this pain that I think is going to linger as a result of COVID in 2022.
I keep hearing two different things from people. We keep hearing about the Great Resignation, a lot of people leaving their jobs. And on the flip side, I hear from people that I know who are looking for work, saying they can't find any work. How do you address people who are either, one, considering leaving their job during the pandemic, or two, really struggling to find work? And, we see signs out there hiring in a lot of places. What's your message?
Some of the problem is mismatch in terms of how well employers are using these. Everything has shifted online, and that's not easy for all workers to apply for those jobs online. They may even be in dead zones, and that's really hard, or they may not have the broadband to be able to put their full resume up, or they may not be accustomed to actually making applications online. And I think that's a real issue. And these job descriptions, they often have sort of hurdles in it that aren't necessary, maybe a college degree that isn't actually necessary for the job, and that maybe be closing out some very talented and skilled workers. So employers have to get a lot more creative and deal with the hurdles that a lot of employees feel. There also is a mismatch to where the jobs are in suburban areas and resort areas, in leisure and hospitality, but not in the urban centers that we saw in the past. Hopefully some of those jobs will come back over the course of 2022, but we're not going to see the kind of volume that we did in the past in urban centers that are, certainly satisfied by mass transit. Those are really big hurdles in terms of commuting costs for workers out there. And I think that's something that employers often don't think about, is where are the workers living versus where are the jobs existing? And those are issues we need to sort of bridge the gap on as we get into the second half of 2022.
We'll wait and see and hope for some positive outcomes. Diane Swank, thank you for your time.
I'm Norah O'Donnell in our nation's capital. We're here at the White House with the President of the United States.
Thanks for having me. I appreciate it.
The Supreme Court building behind me is once again at the center of a monumental battle. Tonight, a congressional investigation sparked by reporting from CBS News. Our exclusive access to the presidential platform. We will witness yet another moment in history.
The CBS Evening News with Norah O'Donnell from Washington, D.C. An original documentary on CBSN.
50 shows running, the lights blinking.
People fight their entire career to get to Broadway.
You've trained your entire life.
Spotlights, drama, passion.
This is what we live for.
Until COVID turned off the lights.
It's like going from a bright light to pitch black.
scenes from Broadway's unique struggle with COVID.
It was devastating.
Broadway contributes about $15 billion to New York City's economy and 100,000 jobs.
The sound team, the lighting team, everyone.
The world does not realize how big this is.
This is how we make money.
This is a specialized industry. You don't tell a doctor to go get a serving job. You just, why are we different?
Are we going to be able to pay our rent? Am I going to have food?
What will happen in Broadway's new opening act?
We're in uncharted waters again.
The show must go on.
There is reason to hope again.
I think people are going to be crying. I know I will.
An originals documentary on CBSN. Stream now.
Welcome to CBS Mornings.
Up next, stories you'll be talking about today.
That's a big deal. People stop me on the street and say, I always learn something new every day when I watch your show.
This morning, we're going to begin with some good news.
Oh, you just put me in a good mood.
Just follow me. I'll lead the way.
There's always something new under the sun. CBS Mornings, weekdays on CBS.
Tennis star Novak Djokovic will be spending the weekend holed up in an Australian immigration detention hotel. He was denied entry into Australia this week after being granted a medical exemption from COVID vaccination requirements. CBS News foreign correspondent Roxana Saberi has more.
Chaos and confusion reign. Just days before the world's top men's tennis player hoped to relive these scenes from last year's Australian Open.
We want to head back to Brunswick, Georgia, where the sentencing hearing is back underway for the men convicted of killing Ahmaud Arbery. The judge is about to issue the sentence. Let's listen.
All right, the way the court's going to address this, I'm going to make a few remarks and then address each one of the defendants with regard to sentencing. And the remarks are intended to be general, but also taken into consideration in the individual sentencing portion of the court's statement. So that's how we intend to proceed. So the court has heard the evidence in the case, has accepted the jury's verdict, listened to the presentations here today in aggravation and mitigation, and candidly have spent a lot of time thinking about this. This is a case that has taken a lot of time and energy on a lot of people's parts, and has been a case of note, not just in this community, but really in a lot of communities. What we're here today to determine is what an appropriate sentence is, quite separate from the notoriety of the case and any other outside influence that may exist. And so the court is going to be very careful in explaining that the court has considered just the evidence and what is appropriate under the circumstances of this case to consider in the Superior Court. So that all being said, let me start with this statement. As we all now know, based upon the verdict that was rendered in this court in November, Ahmaud Arbery was murdered. It's a tragedy. It's a tragedy on many, many levels. On February 23rd of 2020, almost 2 years ago, a resident of Glynn County, a graduate of Brunswick High, a son, a brother, a young man with dreams, was gunned down in this community. As we understand it, he left his home apparently to go for a run, and he ended up running for his life. He entered the English home at approximately 1:04 p.m. and left that home at about 1:08 on that day. At 1:14, Greg McMichael calls 911 to let them know that there's a black male running down the street. And within moments, Ahmaud Arbery is shot and killed. The three men that are now before this court chased him in a residential neighborhood for at least 5 minutes in pickup trucks, armed with a shotgun and a .357 revolver. The state mentioned this today about the time period, but I do want to put that time period in context. And the only way I could think to do so may be a little theatrical, but I think it's appropriate. I want us all to get a concept of time. And so what I'm going to do is I'm going to sit silently for 1 minute. And that 1 minute represents a fraction of the time that Ahmaud Arbery was running in Satilla Shores. That's approximately a minute. Again, the chase that occurred in Satilla Shores occurred over about a 5-minute period. And when I thought about this, I thought from a lot of different angles, and I kept coming back to the terror that must have been in the mind of the young man running through Satilla Shores. The jury heard the evidence and returned a verdict. And what a difficult job they had under the circumstances. Without any comment on the verdict itself, I think all counsel will agree and accept that this was a very difficult case to even get a jury impaneled on. And there are issues out there with regard to the jury that were brought up in the press and elsewhere. But I want to give credit to those members of the panel, not because of their verdict, just because of the fact that they were willing to go through the process that they went through with the state, with the defense, and with this court. We're here today to sentence the defendants. In discharging the duty, this court is required to consider all mitigating and aggravating circumstances. The court has considered those circumstances, including but not limited to all aspects of the crimes charged, the past criminal record or lack thereof of the defendants. I've also considered any lawful evidence which tends to show the motive of the defendants, their lack of remorse, their general moral character, and any predisposition to commit other crimes. Now, I think in this case, the record speaks for itself, and the defendant's own words, I think, guide this court with regard to sentencing. Went back through my notes and other resources to pull some of the quotes that we have in this case. I'll start with Greg McMichael. In my opinion, Greg McMichael, very early on in this, tried to establish a narrative. He made comments like, Ahmaud Arbery was trapped like a rat. Stop or I'll blow your, and I won't repeat it again, head off. He effectively admitted that he wasn't sure what Ahmaud Arbery had done wrong. Quote, I don't think the guy has actually stolen anything out there, or if he did, it was early in the process. But he keeps going back over and over again into this damn house. Again, back to the narrative. Told Travis, you have no choice. Told another individual at the scene, this guy ain't no shuffler, this guy's an asshole. Commented that he wanted him, Ahmaud Arbery, to know that we weren't playing. If I could have gotten a shot at the guy, I would have shot him. Travis McMichael claims he was in shock. But it's interesting because he talks about his concern for his child and his own well-being. part of this was while the victim was actually laying there in the street. Commented, "This is the worst day of my life." Well, I think it's been touched on here today. There were other individuals that were impacted. I look at the video of this incident. When I say the video, I think everybody knows what we're talking about, but there was one part of it that struck me as absolutely chilling, and that is, I believe it's in the enhanced video provided by the GBI. There's a frame where I believe Ahmaud Arbery, it looks to be, if he's 20 yards out, that may be close, 30 yards out. And it's the frame of Travis McMichael lifting the shotgun to fire at Ahmaud Arbery. And you watch that with context. And when I say context, after hearing the evidence in this case, again, thinking about a young man that had been running at that point for almost 5 minutes, and it is a chilling, truly disturbing scene. And we got there because Travis McMichael's father saw Ahmaud Arbery hauling down the street and calls out, "Let's go." At that point, Travis McMichael, despite whatever may have been going on in his life at that time, with regard to family or otherwise, just goes, grabs a shotgun and goes because he assumes that it is the right thing to do. Ahmaud Arbery was then hunted down and shot. And he was killed because individuals here in this courtroom took the law into their own hands. Mr. Bryan, he joined in after calling out to the McMichaels. Y'all got him? Claimed he didn't know what was going on, but obviously wanted to know if this individual who was running through the neighborhood, who he didn't know, had been caught in some way. Said, quote, "I figured he'd done something wrong, but I didn't know for sure." All right, that wasn't actually the quote. Those quotes are two separate quotes. "Didn't know for sure. I thought he would get away." And this is the part that is disturbing to me with Roddie Bryan. If the guy would have stopped, this would have never happened. All of these quotes give context, I think, to the video that we saw during the case. And Miss Wanda Cooper-Jones this morning made a statement that I think, when you look at these statements and you see the videos, is very true. And that is, she said, when they could not scare or intimidate him, they killed him. There's been discussion about remorse. And I agree with counsel that it is dangerous for defendants who have multiple prosecutions against them to make statements of remorse. But remorse isn't something that is simply a statement of regret. Remorse, I think, can be determined by looking at somebody's reaction to difficult circumstances and the reality of the situation that they're in. Again, it doesn't require an apology, and quite honestly, sometimes apologies are made simply to get past problems. Remorse is something that's felt and demonstrated. In this case, getting back to the video, again, after Ahmaud Arbery fell, the McMichaels turned their backs. It's, again, a disturbing image, and they walked away. This was a killing. It was callous, and it occurred, as far as the court is concerned, based upon the evidence, because confrontation was being sought. I think the statement was made during closing arguments. It's interesting to note that the most violent crime in Satilla Shores was the murder of Ahmaud Arbery. So sentencing does not generally provide closure. I think Ms. Wanda Cooper-Jones also talked about closure, but I don't find that it really does, and I think that's an unfortunate thing. Because in this case, I think many people are seeking closure. The mother, the father, the community, and maybe even parts of the nation. But closure is hard to define and is a granular concept. It's seen differently by all depending on their perspective and the prism of your lives. Instead of closure, maybe we best see today's proceeding as an exercise in accountability. We are all accountable for our own actions. Sometimes in today's day and age, that statement is lost upon many. And today the defendants are being held accountable for their actions here in Superior Court. Today demonstrates that everybody is accountable to the rule of law. Taking the law into your own hands is a dangerous endeavor. I'm not sure how this comes across. I'll say it anyway. I think ultimately, with regard to the murder of Ahmaud Arbery, it holds us all accountable. I've read somewhere, and I don't remember where it was, that at a minimum, Ahmaud Arbery's death should force us to consider expanding our definition of what a neighbor may be and how we treat them. I argue that maybe a neighbor is more than the people who just own property around your house. I also believe that in assuming the worst in others, we show our worst character. Assuming the best in others is always the best course of action. And maybe those are the grand lessons from this case. I will let others spend as much time as they want writing about it and talking about it. But those are my general thoughts with regard to this case and sentencing. That said, with regard to the sentence in this case, as to Travis McMichael, Mr. McMichael, the court sentences you as follows. Count 1, malice murder, life without the possibility of parole. Count 2, felony murder, is vacated by operation of law. Count 3, felony murder, vacated by operation of law. Count 4, felony murder, vacated by operation of law. Count 5, felony murder, vacated by operation of law. Count 6, aggravated assault, merges into count 1. Count 7, aggravated assault. The court sentences the defendant to 20 years consecutive to count 1. Count 8, false imprisonment, merges into count 1. Count 9, attempted false imprisonment, 5 years concurrent to count 7. That is life plus 20. Greg McMichael, the court sentences you as follows. Count 1, malice murder, defendant was found not guilty. Count 2, felony murder, life without the possibility of parole. Count 3, felony murder, vacated. When I say vacated, it's vacated by operation of law in all cases. I'm not going to repeat it. Count 4, vacated. Count 5, vacated. Count 6 merges into count 2. Count 7, aggravated assault, 20 years consecutive to count 2. Count 8, 10 years concurrent to count 7. Count 9, 5 years concurrent to count 7. That is life plus 20 years. Roddie, Bryan, I do want to separate a little bit because the state is making a different recommendation. And despite the back and forth that Mr. Goff and I had during this case, I do want to point out a couple things that he raised that I think are appropriate to raise with regard to the sentence. As far as the remorse, I think Roddie Bryan stands in very different shoes. It is obvious from the beginning that he questioned the tragedy that had occurred at the scene and was on, I believe, I can't remember whose body cam, but the body cam, in fact, questioning whether or not what had occurred, and then took steps early on in this process, I think, that demonstrated that he had grave concerns that what had occurred should not have occurred. And I think that does make Mr. Bryan's situation a little bit different. However, Mr. Bryan has been convicted of felony murder. And I do not believe it can be disputed based on the facts of this case, that the verdict was an appropriate verdict based upon the evidence presented, at least. And when I say appropriate, what I mean is legal. Because I believe there's been some discussion about some differences between Mr. Bryan and the McMichaels. There may be some differences, but it does not change the fact that was it not for the fact that Mr. Bryan used his vehicle in a way to impede Mr. Arbery's course of travel this may not have ever occurred, and that is sufficient for felony murder. He did cooperate with law enforcement. I will point out Mr. Goff, 1710(1)B. There's actually a case out of Chatham County that says it would not apply under the circumstances of this case. So the court, recognizing that Mr. Bryan's position is different, again, Mr. Bryan was found not guilty on count 1 and count 2. The court sentences Mr. Bryan to life with the possibility of parole on count 3. Count 4 is vacated. Count 5 is vacated. Count 6, the defendant was found not guilty. Count 7 merges into count 3. The defendant is sentenced to 10 years consecutive to count 3 on count 8 and 5 years concurrent with count 8. Both of those counts, though, will be suspended sentences, which gives Mr. Bryan a life with the possibility of parole sentence. Those are the sentences. The court having pronounced sentence, first with regard to Travis McMichael. Mr. McMichael, you are hereby notified that under the law of Georgia, you are entitled to appeal the guilty verdict of the jury, and if you decide to do so, you must file your appeal within 30 days of this date. You are also informed that you have the right to retain a lawyer of your own choice to represent you on your post-trial motions and appeals to the appropriate appellate court of Georgia. If you cannot afford a lawyer, the court will appoint one for you. You are entitled to and will be given a transcript of all pretrial, trial, and post-trial matters without cost to you if you cannot afford a transcript. You may file a motion for a new trial, or you may appeal your case directly to the appropriate appellate court of Georgia for review. You are also advised that the statute of limitations for habeas corpus in this state is 4 years in the case of felonies and 1 year in the case of misdemeanors. The statute begins to run from the date the conviction becomes final. And just to be clear on the record, I'm going to go through the statement with regard to each defendant. So as to Gregory McMichael, you are hereby notified that under the law of Georgia, you are entitled to appeal the guilty verdict of the jury, and if you decide to do so, you must file your appeal within 30 days of this date. You are also informed that you have the right to retain a lawyer of your own choice to represent you on your post-trial motions and appeals to the appropriate appellate court of Georgia. If you cannot afford a lawyer, the court will appoint one for you. You are entitled to and will be given a transcript of all pretrial, trial, and post-trial matters without cost to you if you cannot afford a transcript. You may file a motion for a new trial, or you may appeal your case directly to the appropriate appellate court of Georgia. You are also advised that the statute of limitations for habeas corpus in this state is 4 years in the case of felonies and 1 year in the case of misdemeanors. The statute begins to run from the date the conviction becomes final. And then finally, Mr. Bryan, you are hereby notified that under the law of Georgia, you are entitled to appeal the guilty verdict of the jury, and if you decide to do so, you must file your appeal within 30 days of this date. You are also informed that you have the right to retain a lawyer of your own choice to represent you on your post-trial motions and appeals to the appropriate appellate court of Georgia. If you cannot afford a lawyer, the court will appoint one for you. You are entitled to and will be given a transcript of all pretrial, trial, and post-trial matters without cost to you if you cannot afford a transcript. You may file a motion for a new trial, or you may appeal your case directly to the appropriate appellate court of Georgia for review. You are also advised that the statute of limitations for habeas corpus in this state is 4 years in the case of felonies and 1 year in the case of misdemeanors. The statute begins to run from the date the conviction becomes final. Don't have a blue or black pen. Is there a blue or black pen down there? Thank you. The court has executed the statement of appeal for Travis McMichael, Greg McMichael, and William R. Bryan. If I could please have counsel and the defendants execute the statements of appeal to confirm they've been given, or the notice has been given. Anything further from the state?
Yes, Your Honor. The state would ask for a condition imposed along with this sentence, and that is this, that the defendants are not allowed to make any money off of their actions, such as a book deal, a movie deal, social media deal, or anything along any way, shape, or form, make any money off of this experience, this conviction, and this trial. And that should any money be made, that it go into a fund for the Arbery family. And I've had this condition imposed before, and given the nature of this case, we just seek to make sure that, based on their actions, having been found guilty of murder, that they do not then reap some sort of profit or benefit off of their actions via such remuneration to or from anyone in the form of, like I said, book deals, movie deals, consulting fees, or telling their story to someone in exchange for money.
There was a statute on this, but maybe I'm wrong.
It's not a SAM statute in other states. I'm not aware of Georgia's. If there is, I assume cite it.
Well, yeah, let's do this. I submit something more formal to the court. I'll go ahead and take a look at it.
Thank you, Your Honor.
And Judge, well, when the court does that, my only concern.
We've been watching the sentencing of the 3 men convicted of killing Ahmaud Arbery. The judge called the murder a callous killing. He sentenced Travis McMichael to life in prison with no possibility of parole, and Gregory McMichael to life in prison with no possibility of parole. These were the maximum sentences. He sentenced William Roddie Bryan to life in prison with the possibility of parole. I want to bring in CBS News senior national correspondent Mark Strassman, who is outside the courtroom in Brunswick, Georgia, as well as CBS News legal contributor Rebecca Roddie. Rebecca, let's begin with you. The prosecutors accused the convicted men of vigilantism before the sentencing. Meanwhile, the defense lawyers argued for a lighter sentence, saying the men deserve a shot at redemption. What did you make of the sentencing?
Well, first of all, I want to say that I thought the judge was incredibly careful and his words were well considered. He didn't say anything that would rile up anybody or create more public sort of upset and uproar over the case, but he did point to several important moments in this trial and pieces of evidence that supported his ultimate sentence. In terms of the arguments that you just mentioned, in terms of the notion of vigilantism, I think that that really went to the prosecutor's notion that these people thought that they were above the law. They presented a defense and continued to do so in sentencing, that they were merely trying to protect their neighbors. And this failed as a legal matter before the jury, and I think it failed as well before the judge, because as he said, why do you view your neighbors as simply the people who live a block away from you and not more broadly the public? Why did they have no empathy for this man whom they killed? And, you know, this, I think, was key in terms of the sentencing, was this lack of remorse that he saw, both in terms of the nature of the defense, but also in terms of the words that they said and their actions on that video, that they turned their backs on the dead body of Ahmaud Arbery after having killed him, that somebody who had done this, you know, mistakenly or out of self-defense would not have acted that way. And I think that that was a very powerful point that the judge made and a powerful argument that the prosecution make. Now, I will say about the defense, they did point out the nature of this felony murder charge, which is something that criminal justice reformers have been pointing to in other contexts quite a lot. You can be guilty of murder even if you did not intend to kill anybody, and only if you intended to commit a felony. And that's a harsh charge. And in other contexts, it's been used against people, you know, who are not powerful people. And so the defense tried to build an argument saying that, you know, this is unfair. These, you know, at least Roddie Bryan and Greg McMichael did not necessarily intend to do this, and they committed felony murder, and that is not something that ought to come with this severe sentence. But you know, the judge issued the sentences according to the law and what he thought would be appropriate given the sentencing information and the evidence in the case.
Certainly powerful statements by the judge, who started off talking about all the time that he spent thinking of this, of course, a really difficult case. for him to hear, I'm sure. I want to go over to Mark. Mark, you've been outside the courtroom. Members of Ahmaud Arbery's family spoke before the sentencing. What stood out to you?
Well, Nikki, before the sentencing was announced, before the judge described this exercise in accountability, the courtroom and the judge in particular heard, of course, from Ahmaud Arbery's father, his mother, his sister. And here's what came across to me. It's been almost 2 years since Arbery was shot and killed running for his life through that neighborhood. And here we are 23 months later, and what came across from the stand, from the mom, the dad, the sister, was how raw this loss still is to these folks. How the defendants may lose their freedom, but the family is going to lose something that they can never possibly replace. And that really came across. The other thing, the point that they made, clearly pushing for a sentence of life without parole for all three, was the sense that they believe that these defendants have shown no sign of remorse and therefore deserve no possibility of leniency. In 2 of the 3 cases, they got what they wanted. As the mother put it on the stand, they were fully committed to their crimes. They should be fully committed to the consequences of those crimes. And so the rawness of the loss and the zeal that they have for a full measure of justice for the defendants, I would say, Nikki, the 2 things that came most strongly across to me.
It was really powerful to hear Ahmaud's parents. There's nothing more unthinkable, of course, than the loss of your child. Mark, what has the impact been in the community in Brunswick, Georgia, from this case?
Well, you see these folks up behind me, Nikki. These are mostly supporters of Ahmaud Arbery's family. There's a speaker outside the Glynn County Courthouse, and when the judge announced a life without possibility of parole for each of the first 2 defendants, big cheer went up. Big cheer went up. And I think in general, there's going to be a sense of relief here. Brunswick did not want to become another Ferguson, another Dateline where a sense of injustice led to upheaval in the community. And clearly, there doesn't seem to be any suggestion that that is now going to happen. I think people here, by and large, are going to be relieved at both the verdicts and at the sentences. And you recall, too, Nikki, how hard it was in this community just to seat the jury. It took almost 3 weeks to seat this jury, small community, lots of publicity in this case. And when they finally did seat the jury, it was 11 white jurors and 1 black juror. And that, in the eyes of many people, could have been problematic. In the end, the verdicts that they delivered almost have an enhanced credibility in the eyes of a lot of people here. That is, 11 white jurors and 1 black juror all agreed this was wrong, this was murder, these defendants deserve to pay. Nikki?
Also notice the judge said this is a case of note. Certainly the country has been watching this case for the past 2 years, all eyes on the trial, waiting for the sentencing. Today, I'm glad to see a sense of peace behind you there, Mark. Thank you. Rebecca, I want to come back to you. And the judge touched on this a little bit during his final statements. Do the convicted have any recourse at this point? And what are your overall takeaways from this case?
Yes, so there will undoubtedly be an appeal. There are legal questions that were determined. There were some evidentiary questions, and those can all be the basis for appeal. In following this case, I didn't see anything that immediately jumped out at me that seemed like it would warrant reversal. So my guess is that those appeals will not be successful, but the defense absolutely has a right to pursue them and most likely will. Of course, there are also those federal charges that remain, the hate crime charges under the federal laws, and the defendants will have to proceed on those charges as well. So their legal drama is not over, even though this case itself is over, and their fate has really been determined at this point, I think, barring some unexpected surprise that might come up. But otherwise, it seems like those appeals will happen, but will likely be unsuccessful. And, you know, in terms of my take on this case, it to me, one of the takeaways, I mentioned before, the one that the judge mentioned, which was about the importance of empathy for more than the people just in your neighborhood. But, to me, there's a legal moral of the story, which is that that courtrooms and legal procedure really do still work, and that there is a reason to respect that process and allow it to proceed as it goes. This was a case with so much emotion, understandably, and people were so eager to see, certain conclusions and certain consequences, but allowing courtrooms to proceed as they do, sometimes to disappointment and sometimes not, is the way that this country works. And I think that this is another example of, even in these charged times, even in the case in which, such important issues are being, in some ways on trial as well, question of racism in our country, all of those were being kind of thrown onto this case and this trial. To me, the criminal law is not particularly well positioned to answer those larger questions, but it does do a good job in these particular circumstances of looking at the facts and applying the law. And so I think, to me, that's an important moral of the story as well.
And on this sentencing day, let us take a moment to remember Ahmaud Arbery. Mark Strassman and Rebecca Roifi, thank you. We're going to take a quick break. More news is next here on CBSN. CBS News, always on.
I'm Norah O'Donnell in our nation's capital. We're here at the White House with the President of the United States.
Thanks for having me. I appreciate it.
The Supreme Court building behind me is once again at the center of a monumental battle. Tonight, a congressional investigation sparked by reporting from CBS News. Our exclusive access to the presidential platform. We will witness yet another moment in history.
The CBS Evening News with Norah O'Donnell from Washington, D.C. An original documentary on CBSN.
50 shows running, the lights blinking.
People fight their entire career to get to Broadway.
You've trained your entire life.
Spotlights, drama, passion.
This is what we live for.
Until COVID turned off the lights.
It's like going from a bright light to pitch black.
Scenes from Broadway's unique struggle with COVID.
It was devastating.
Broadway contributes about $15 billion